Welcome to today's Research Digest. In this video, we summarize a recent paper by Professor Christoph Busch titled Consumer Law for AI Agents, published through Yale University in 2025. This paper asks a simple but urgent question. Is European Union consumer law ready for the rise of AI agents that shop on our behalf? Before we begin, a quick disclaimer. This video is for educational and research purposes only. It does not constitute legal advice. For specific legal questions, please consult a qualified professional. Let's get started. The AI landscape is undergoing a fundamental shift. Since the release of ChatGPT in November 2022, most consumer-facing AI has operated in an advisory role, answering questions, generating images, and making suggestions. Busch calls this Phase 1, generative AI. Here, the consumer remains the decision-maker, and AI merely augments the process. But we are now entering Phase 2, agentic AI. In this phase, AI systems move from advisors to actors. They don't just suggest what you should buy, they go ahead and buy it for you, with limited human supervision. This new breed of AI consumer is what Busch calls a Custobot, a portmanteau of customer and robot. As Jonathan Zittrain has put it, this is a crossing of the blood-brain barrier between digital advice and analog action. To understand why this shift matters, consider how the purchasing journey changes. In the traditional human journey, a consumer searches through a search engine, browses websites and apps, evaluates user interfaces, reads reviews, and then clicks buy. Gatekeepers, platforms, search engines, app stores control access at every step. The Custobot journey looks entirely different. The human sets parameters and preferences up front. The AI agent then operates through an app-less interface, communicating directly with sellers through APIs and agent-to-agent interactions, and ultimately completing an automated purchase. The market shift Busch envisions is dramatic. Online shops may evolve into what he calls ghost supermarkets, digital storefronts designed purely for AI agent navigation, abandoning human-optimized user interfaces entirely. This transformation also disrupts the economics of online marketing. Currently, search engine optimization, or SEO, drives how businesses compete for visibility. Human consumers tend to click the top results, a phenomenon known as position bias, regardless of whether those results are actually the best option. AI agents, however, are immune to position bias. They don't care about ranking order. Instead, they objectively compare thousands of data points simultaneously, evaluating products on price, specs, and reviews. Busch argues that this could render traditional SEO irrelevant and give rise to a new strategy he calls AI agent optimization, or AO. The downstream impact is significant. Brand loyalty for commodity products could collapse as Custobots effortlessly find cheaper, equally effective alternatives. Now we come to the core legal challenge. European Union consumer law is built on a silent assumption that purchasing decisions are made by humans. The entire regulatory architecture, its information requirements, its protections against manipulation, its concept of the average consumer, is designed with human cognition and human vulnerabilities in mind. But as Custobots enter the marketplace, this human-centric foundation begins to crack. The premise was that EU rules exist to protect human autonomy and correct cognitive biases. The reality is that traditional human consumers will now permanently coexist with autonomous AI agents. And the resulting crisis is that regulations engineered for human comprehension fundamentally misfire when applied to machines. One of Busch's most thought-provoking observations concerns the average consumer test. Under EU law, courts assess whether a commercial practice is unfair by asking how a reasonably well-informed, reasonably observant, and circumspect consumer would react. This standard maps poorly onto AI agents. Compared to a human consumer who suffers from present bias, choice overload, and status quo bias, a Custobot can process infinite comparisons effortlessly, ignore emotional advertising, and instantly cancel and use subscriptions without hesitation. In some ways, AI agents come closer to the idealized, rational consumer that EU law always assumed but never actually observed. However, the picture is not so simple. Research in machine psychology shows that large language models can inherit biases from their training data and may even exhibit deceptive, goal-oriented behaviors. This raises a provocative question that Busch leaves open. Does agentic commerce require an entirely new, average Custobot test? Another pillar of consumer law under pressure is the information paradigm. Pre-contractual disclosure requirements, mandating that sellers provide detailed product information, are one of the most widely used tools in EU consumer protection. But behavioral research has long questioned their effectiveness. For human consumers, more information often means worse decisions due to information overload. AI agents turn this problem on its head. They can process vast amounts of data without cognitive fatigue. Instead of overwhelming the consumer, detailed disclosures become raw material that AI agents filter and personalize. Busch calls this decentralized personalization, where the consumer's own AI agent, rather than the seller, curates relevant information. The legal pivot Busch suggests is this. Instead of reducing disclosures, regulations should mandate machine-readable formats like the EU's upcoming digital product passport, so that Custobots can do the reading and filtering for us. Beyond simply filtering information, AI agents can be designed as what Busch calls choice engines, systems that actively steer consumer decisions. This introduces a spectrum of paternalism. At one end, an AI agent acts as a neutral assistant, executing commands without judgment. In the middle, it functions as an empowerment tool, offering highly personalized nudges based on user data, for example, suggesting a cheaper or healthier alternative. At the far end, the agent becomes a paternalistic restrictor, factoring in macro externalities and potentially refusing transactions that exceed a certain carbon footprint. AI agents, Busch observes, are capable of correcting human behavioral vulnerabilities, but they also raise profound questions about freedom of choice in the digital marketplace. If AI agents are less susceptible to traditional manipulation tactics, what new threats emerge? Busch introduces the concept of digital vulnerability 2.0. Today, malicious sellers exploit human psychology through dark patterns, fake countdown timers, false scarcity labels, and misleading button designs. AI agents are largely immune to these tricks, but they face an entirely different category of threats. First, adversarial images, subtle pixel-level modifications invisible to humans, but capable of tricking an AI's visual classification system, for example, causing a neural network to misread a manipulated stop sign. In e-commerce, such techniques could become AI-specific dark patterns. Second, prompt injection attacks, malicious hidden text embedded in website code that hijacks an AI agent, potentially causing it to leak user data or trigger unauthorized fund transfers. These are the new frontiers of digital manipulation in the agentic economy. So how should consumer law respond? Drawing heavily on the European Law Institute's DACC model rules, Busch proposes that consumer policy needs 3 new foundational pillars. Pillar 1, enabling the Custobot economy, creating the legal conditions that allow AI agents to operate in consumer markets. Pillar 2, protecting Custobots against manipulation, developing rules that guard AI agents from adversarial attacks and technical exploitation. Pillar 3, protecting humans against Custobots, ensuring that when AI agents act on behalf of consumers, those consumers remain adequately protected. These 3 pillars must work together as an interlocking system. Under the first pillar, Busch calls for 2 key measures. First, legal recognition. Contracts concluded through an automated digital assistant must not be denied validity simply because a machine was involved. Second, the no-barrier principle. Consumers should have a legal right to use AI agents for transactions. Traders should not be permitted to create terms of service or technical obstacles that ban Custobots from their platforms. However, this principle is not absolute. Busch acknowledges that businesses may retain legitimate interest in blocking AI agents in specific scenarios, for example, preventing sniper bots from hoarding concert tickets or auction items. The second pillar addresses the protection of AI agents themselves against manipulation. Busch highlights an innovative proposal from the Yale DACC model rules. Businesses must not use the structure, design, or manner of operation of their online interfaces in a way that materially distorts or impairs a digital assistant's ability to perform its functions. This legal standard is modeled on Article 25 of the Digital Services Act, which prohibits dark patterns targeting human consumers. Notably, the Yale proposal avoids speaking of free and informed decisions, a concept that would imply AI agents possess free will. Instead, it focuses on the AI's functional capacity, reflecting its instrumental nature. Busch also calls for a research mandate. We must rapidly develop taxonomies of machine psychology to legally define and ban AI-specific malicious design patterns. The third pillar addresses perhaps the most fundamental conceptual shift. Traditional consumer law focuses protection around the magical moment when a contract is concluded, the point where a human clicks buy. But in the Custobot economy, no human is present at checkout. The meaningful human decision happens much earlier, when the consumer deploys the AI agent and sets its parameters. This means consumer protection must shift backward in time, from the point of transaction to the point of configuration. In the future timeline, Busch argues, the magical moment is when the human sets the AI's parameters. Everything that follows, the browsing, the comparison, the purchase, is autonomous. This calls for a fundamental reorientation, from contract law-based protection to design-based consumer protection, where the focus falls on how AI agents are built, configured, and regulated before they ever enter the marketplace. Busch concludes with a clear message to policymakers. The time to act is now. The one-size-fits-all model of consumer law is obsolete. The market is already splintering into 3 categories of participants: traditional human consumers, augmented humans using AI as an advisory tool, and fully autonomous algorithmic agents. We cannot wait for what Busch calls the iPhone moment of agentic AI, the point where the technology becomes mainstream and irreversible. The regulatory infrastructure for the Custobot economy must be built today. Thank you for watching. If you found this summary helpful, please like, subscribe, and leave your thoughts in the comments. See you in the next video.